Okay, you guys are good to go now. Sorry. Thank you so much for your patience.
No problem. Thank you. Okay. So I'll go ahead and call the Board of Zoning Appeals meeting for July 27th, 2020 to order. Again, a reminder, if you're not speaking or until it's your turn to speak, if you would keep your systems on mute so we can avoid as much background noise as possible. We have a full board present here today, as well as the city planner and city attorneys. I see several guests. We have 3 dockets to go through today, so I assume various representation among all. Mr. Prime, I see you are out there and representing, I believe, all 3 dockets. Is that correct?
Has joined the meeting.
Just 2.
Just 2? Okay, I thought you were on each of them.
Yes, no, I had the second and third.
Okay. And I see, again, a lot of guest speakers. I'm not going to go through everybody's name now, but when the time comes for whichever docket you are on to speak to, if you'll let us know your intent to present. So this will be, it can be a little chaotic, so just bear with us. All right. First item on the agenda is the approval of minutes from Monday, June 22nd. I'll take a motion to approve.
Motion to approve.
Was that Mr. Polar?
Motion to approve.
Okay.
Second.
Okay. Motion by Mr. Polar, second by Mrs. Peters to approve. Mr. Smith?
Yes.
Mr. Polar?
Yes.
Mr. Foster?
Yes.
And Mrs. Peters?
Yes.
And I'm a yes. Motion carries 5-0 to approve the minutes. Sorry, taking a little note there real quick. Okay. Any special requests or continuances that are not noted on the agenda, Ed?
None that I know of.
Okay. Sergey?
Nothing from legal.
We're getting a lot of background noise from someone. I'm trying to see if I can tell where that's coming from. Trent, I think it might be you. Okay. Next item is the findings of fact for docket V 2020-10, the dimensional variance for South Park Business Center. I need a motion to take our final action on that.
Chairman, in consideration of the statutory criteria, I move that we adopt the written findings of fact as presented, incorporating the evidence submitted into the record as our final decision and final action for variance petition number V 2020-10.
Second.
That's second by Mr. Smith or Mr. Foster?
I believe it's Mr. Smith.
Okay. Motion by Mrs. Peters, second by Mr. Smith. Mr. Puller?
Yay.
Mr. Smith?
Yes.
Mrs. Peters?
Yes.
Mr. Foster?
Yes.
And I'm a yes. Motion carries 5-0. All right. Moving on. Next item on the agenda is old business, docket V 2020-11, use variance for the property at 1444 West Dimmery Road. Petitioner is Austin Etter and Keith Etter. And then I show represented by Eric Prime, attorney for the petitioners, but maybe that is incorrect on the agenda.
No, that is correct. I thought you were talking about the item that was preceding us.
Oh, sorry.
That's
Okay.
the third item.
Gotcha. All right. So is there anyone besides Mr. Etter and Mr. Prime that is going to speak for or against this document?
Yes, Lee Money. I represent the Ashwood Homeowners Association, and we will be speaking in opposition. I'll be speaking on their behalf in opposition to the petition.
Okay. Thank you, Mr. Money. Anyone else or any individuals within your group that would be speaking?
There are a number of individuals who may or may not wish to speak on their own, because I don't represent all the individuals, just the Homeowners Association officially. However, they're essentially a unified voice. There may be others. It may be that I ask Tom Brink to comment on some of his submissions that the the BZA has. And I actually sitting to my next to me is Bruce Richardson, resident and realtor, and I'm going to have him offer an opinion on values. And so that's my understanding of how we are going to.
Okay. So we need to get everybody sworn in. It's not the easiest thing to do with video. So Lori, I don't know because I don't think you're going to be able to see everybody at the same time. So do you want me to go through individually, or how do you want to do this, Lori?
I can see Lee and I can see Eric, and those two are speaking. So I'll just swear those two in real quick, and then we'll
So-
just go from there.
Mr. Money and Mr. Prime, if you two could raise your right hand and be sworn in by Lori.
Do you swear under penalties for perjury that the testimony about the given is true to the best of your knowledge?
I do.
Okay.
Yeah, I might ask that you do the same for Bruce Richardson, who's sitting here at table with me to say this time later.
Okay,
Yep.
thank you. Bruce,
Go ahead, Mr. Richardson. There.
you swear under penalties for perjury the testimony about to give is true to the best of your knowledge?
I do.
Thank you.
Okay, thank you. If we have anyone else that wants to speak, we'll get them sworn in before they do so later. So, okay, Mr. Prime, you are the petitioner. If you would tell us what you're here for, and we'll go through your testimony and the findings of fact. And you'll have 20 minutes, and then the remonstrators have 20 minutes, and then each of you have 5 minutes of rebuttal.
All right. Thank you, Mr. Chairman. I'm going to ask the IT folks if I can screen share here.
Yes, 1 second. Let me figure out. Was that Andrew? No,
It's
Eric
okay.
Prime.
Okay. You should be able to share your content now.
Can everybody see that? There should be a PowerPoint on the screen.
Yeah.
There is. We're getting a lot of background feedback. I'm not sure where that's coming from. But if everyone could please go on mute except for Mr. Prime right now.
There, that's a little better. And as I said, can everybody see the PowerPoint that's on the screen?
Yes, we can.
Okay, terrific. Thank you very much. By way of introduction, Eric Prime, Van Baylor Law Firm. On behalf of the petitioners, Austin and Keith Etter, we're here about a parcel of property at 1444 West Demery Road in Greenwood. Petitioners are requesting a use variance to allow them to operate the home office of a landscaping company. Its area is currently zoned R1 residential. The business operations would consist of an office use and then vehicle and equipment and tool storage on premise. The work would actually be done remotely at other locations where they are hired to do landscaping. This would just be the base of operations for their operation. All of their other work would occur off-site at their clients' properties. And in addition, petitioner Austin Etter intends to reside at the residence. The sellers of the property, the Bennises, are currently residing there until their home is completed in Ashwood, actually, next door. And the Bennis family actually allowed Ashwood to happen when they sold off a portion of their family farm to Gene Perkins for that purpose. So I'm now showing you the area overview. The parcel that we're discussing, 1444, is outlined in the light blue. You can see Ashwood to the west. There's Forest Lawn Cemetery and Memory Gardens is to the north. And then there are various uses to the south across Demery Road, including Gene Perkins' own construction business. That is I'll zoom in a little on that. Sorry, I don't have a pointer handy, but the larger white barn at the bottom of this photo is Mr. Perkins' property. It's catty corner from this parcel. Then this slide gives you just a little bit more of an aerial overview. You see Mr. Perkins' white barn, and then if you look to the up and to the left, or up and to the right rather, you'll see the barns that are on the Bennis and Eder parcel as well. So we're not asking to make any changes to that physical configuration of the buildings, just asking to be able to use them in their current configuration. This slide is in the Wayback Machine to 1988. You can see that the barns and the home were there at least that far back, but the Bennises have owned, Mrs. Bennis has lived in that property for 60 years, and her parents before her, and it has always been used for either commercial businesses or agricultural uses. So by way of just comparison, Ashwood was actually platted in 1990, 2 years after this aerial photo was taken. So it's important, I think, to look quickly at the staff's report. Staff did recommend that this variance be approved. And I think if you read the historical aspect of the report, it gives you an idea why. As I mentioned earlier, the Bennis family has owned this property for now 2 generations. Sandra Bennis has lived on the property for 60 years. In prior years, the Bennis operated a plumbing contracting business.
We lost audio, Mr. Prime. Looks like we might have lost him completely.
Mr. Narcer, this is Dale Davis. I've had this issue. If he was on an iPad before, it may have put WebEx to sleep while he was talking. Hopefully he'll be back here in a second.
Gotcha. Okay.
Inside the hardware camera. I don't know where the microphone is here. Oh, here it is. Oh, I'm muted. Okay. What?
But I don't see her.
Yes.
What'd you do that
I was hiding my camera. Susan Bousman, Susan Dew.
for? Oh, you don't want to be.
I didn't. Tom Burke, Tom Clemens, they don't have me. I guess I didn't get added to the list, so they lost their connection to this guy.
So you lost it?
Huh?
Everybody else?
No, the guy presenting lost it.
Oh,
He's the
Sorry, I'm trying to connect to Mr. Prime here.
I just sent him a message as well.
Okay. Say, do we have a phone number for him anywhere? We'll give him 30 seconds here, and then I'm not sure where to, well, he's involved in each of the dockets, so we're just going to have to be patient here.
The office number for Van Baylor is 881-7575. I don't know whether he's participating there at the office and could receive that call or whether he would be accessing cell phone. I do not have Eric's cell phone number.
Okay. I can
You
always
guys
give-
want me to call him, Kenny?
Yeah, if you would. See if you can get connected to him.
Oh my gosh.
Laundry list of voice options, probably.
They have a very nice voice recording. It tells you all about the firm.
That's right. Yeah, it looks like he's completely dropped now, so.
Hey, Dale,
Yeah,
do you have Eric Prime's cell phone number by chance in the file?
I'm getting in CityWorks now to see if it's in here.
Okay. I tried on my phone as well.
Yeah, I'm not sure what protocol is going to be here if we can't connect to him.
Hey, Mr. President, would it be advisable to, while we're waiting for some demonstrators, and then when Mr. Prime gets on, go back for?
Well, I would be all for that, but my fear is we need Mr. Prime to hear that testimony so that he can respond to it.
There.
Unfortunately, Mr. Prime represents the rest of the dockets as
Yeah.
well. So
That's what I was saying. He represents the
that
other two
is the
documents,
complicated part of it.
so we can't jump ahead.
I am now going through every application we have from Mr. Prime to see if I can find a cell phone number.
I actually know someone that may.
Mr. President, I've gone through all the applications I can find from Mr. Prime, and they all list his office number, unfortunately.
I attempted to contact his partner, Tom Vander Lutengaren, but we could not raise Tom on the phone either to see if he could assist us.
I'm gonna shoot him an email real quick. I'll be right back.
There were electrical outages throughout the county. The Franklin Annex actually was without power due to the storm. So it is possible that Tom or that Eric would have lost power out there. Obviously, that's just speculation, but that might explain why we're unable to reach him at all.
Looks like he's back in.
How much of that did you hear?
Not much.
I think the last statement was looking at historical aspect of the report. So,
Yeah, this is telling me the live broadcast was stopped due to screen sharing. Okay, great. Well, let's see. How much time do I have left?
By my clock, it's about 30 seconds, Eric. So just.
Kenny, you're on mute.
Sorry, I got put back on mute. I think you had about 12, 13 minutes left, Eric, if I recall.
Yeah. All right. Well, basically, I'm not going to try to screen share again because that's what wiped me out the last time. What we wanted to talk about was that, Sergey, you said the last thing I said was what?
You're on mute, Sergey.
Yeah. So what we want to talk about basically was that this property's been used for decades by the Bennis family. Sandra Bennis and her husband, Sandy's lived there for 60 years, and her mom and dad before her. The fact that Ashwood condominiums even exist was because the Bennis family sold part of their farm ground to Gene Perkins for that development. The staff report, which I had up on the screen, I know all of you have that. I would encourage you to look at staff's comments because they are very instructive. Staff went through the entire history of the parcel, the fact that Bennis has used it as a plumbing business and then later as a yard sign business, the yard signs, the large ones that you put in people's yards for anniversaries and birthdays. That business only ended in 2018. So it has been used either for farm use or commercial use as a plumbing company or a yard sign company since before Ashwood existed. Ashwood was platted in 1990. I showed a aerial of this house and the barns in basically the exact same configuration back from 1988. So all of this predated the majority of the residential development in the area. In addition to that, Gene Perkins, who developed Ashwood, has his business across the street. He runs his construction business and has a huge barn for auto storage and a workshop over there. So there is a mixed use along this corridor, and staff notes that. And I think that's, again, instructive to look and to see. And I ran through the statutory criteria. There are 5 of them, as we said in the petition. And I'll just, in order to save time, I'm not going to go back through that again, but I will ask that our petition be incorporated into the record by reference. We went through each of the statutory criteria and indicated why we thought we met each of those, and I believe we do. But the important aspect of that is probably property values, because usually people come in and complain about something hurting their property values. This parcel, the use of this parcel in a commercial fashion, long predated any of the well, particularly Ashwood, but the majority of the residential uses in the area. And the way we protect that is that we accept and follow to a T the proposed conditions that are in the staff report. And again, while I was offline, I read through all of those for you. So in the interest of time, I'm not going to do that, but there are 6 conditions that staff appended to the staff report. And we are absolutely 100% ready to comply with each one of those. This will not be much of a change at all from what's there now. The buildings won't change. The use won't change really, because it's just going to be things stored in the barn for my client's landscaping business, all of which occurs off premises. There will be no retail sales. There will be no people coming and going to visit. This is not a greenhouse. There are no chemicals stored here, because my client he doesn't apply chemicals. He doesn't do that kind of work. So because we are willing to adhere to all of the conditions that staff indicated, and because my client intends to live in the house, he has every incentive to keep this place spick and span and in good keeping with the neighborhood. And so we would ask that you approve this variance.
So, Sergey, can we take the findings of fact by reference, or do we still need to go through them?
We can, however, I'd prefer that we would run through them as quickly as we can to put it on record. I'm just, there are so many new things, and because of COVID, and the Zoom one is also a new one. So I'm not 100% sure about that, but I would prefer that we run through them as quickly as we can. And
so
one.
I agree. So Eric, we can do this one of 2 ways. I can get you started, and you can read them off, or I can simply read them.
Yeah, Mr. Chairman, I can run through them very quickly.
Okay. So number 1, Eric, the approval will not be injurious to the public health, safety, morals, and general welfare of the community because
there is no use here that has any health or safety issues. We're storing equipment on a 4+ acre property that's well buffered from any other adjacent people. No chemical storage. There's nothing there that's dangerous. I mean, obviously there's some big equipment, but it's going to be in barns. So we believe we comply with that criteria. And again, this area has been used for commercial use in the past, and again, nothing's really changing here. The second criteria is the use and value of the area adjacent to the property included in the variance will not be affected in a substantially adverse manner. And that's really what I spent most of the time coming back online and talking about, was that nothing is being done here that hasn't been done there for decades. And because we are going to adhere to the conditions that the city has requested, that ensures that that adjacent property values won't be affected, because there is no, looking at this property, you won't know that anything was different 6 months from now than it is today. The third criteria is that the need for the variance arises from some condition peculiar to the property. The peculiarity was the property was used this way prior to being annexed into the city in 2010. The annexation caused a change in the zoning to the area, so it kind of overlapped an existing use. And so what we're saying is basically, hey, lots of things in that area have been used this way, including Gene Perkins across the street, using residential, sort of hybrid residential commercial area. And that's exactly what this will be. Mr. Etter will be residing in the residence that is in front of the buildings that will be storing his equipment. But all the work will be done off-site. Fourth criteria is that the strict application of the terms of the zoning ordinance will constitute an unusual and unnecessary hardship. He bought the property thinking that it could be used for commercial because it always had been. If this variance is not granted, it will destroy his intended use of the property. So he thought he had the perfect place to live and to base his equipment and keep an eye on things, and it is. assuming that this variance is granted. The fifth criteria is that the approval doesn't interfere substantially with the comprehensive plan. The comprehensive plan looks at this area as a single-family residential use. The proposed use of this business will, because it's not retail, it's not an active commercial use, it will fit harmoniously with residential use, and in fact, the petitioner will be residing on the property.
Okay. Let me read through the proposed conditions that you referenced so that they're on the record as well. And then we'll close your portion and go to Mr. Money and the demonstrators. So the number one, the existing detached garage, barn, and three-sided shed may be used for operation of petitioner's landscape business for parking and storing of vehicles and trailers, office use, accessory maintenance, and repair of equipment and vehicles, and keeping of customary tools of the trade. Number two, overnight storage of trailers, tractors, and machinery other than vehicles shall be inside the garage or barn. Number three, the following activities shall be prohibited on the property. A, retail sales of plants, landscape materials, tools, or other related landscape supplies. B, storing or stockpiling of plants, mulch, stone, blocks, bricks, or other materials outside except when contained within the bed of a truck or a trailer. C, greenhouse operation. D, storing or stockpiling plant or landscape debris removed from other premises, neither on the ground, on trailers, nor in truck beds. 4, the area of the property used for the landscape business activity shall not extend beyond a distance of 81 feet north of the existing barn, nor more than 50 feet east of the existing barn. 5, driveway and parking areas shall be hard surface asphalt, concrete, or brick stone pavers. Crushed stone or gravel surface shall be prohibited. Hard surface shall be installed on the stone areas to the east and to the north of the existing barn prior to those areas being used as driveway or parking areas. And number 6, petitioner shall submit a landscape buffering plan for the area of the property between the existing garage, barn, and shed and the western property boundary. Buffering shall be extended northward sufficient distance to provide buffering of the driving parking areas north of the existing barn. Said plan shall be subject to review and approval by the planning director. And a note that this condition may be amended provided the said plan is submitted prior to or during the public hearing. Okay, and you're good with all of those you have already stated. Okay, so we will turn it over to Mr. Money.
Thank you.
And you have your 20 minutes to present.
Thank you. We need to start our presentation with the fact that the petitioner does not come into this hearing with clean hands. While we've just gone through a number of conditions they've promised to obey, the beginning of this project saw a much different attitude, and we don't know that we cannot anticipate that same attitude moving forward. To the commission, several exhibits, 11 in all. The first exhibits is the second cease and desist letter that was required in order to get the Edders to actually comply with local ordinance and stop doing business. Even after they were warned by the city the first time, they ignored it. And it was only until the second time that they were presented with the cease and desist that they then changed their mind and said, oh, wait a minute, now maybe we need to comply. And I think that's important here, because we don't have persons who automatically determine we're going to comply with that or took steps to ensure that the property they were buying for the use they thought was zoned appropriately. And quite frankly, it was not. They began constructing driveways. Even after the cease and desist order, the first one was issued, they started producing gravel drives, completely ignoring the city of Greenwood's admonishment, and quite frankly, contrary to the zoning requirements and the use requirements of the city to have hard paved drives. They started simply pouring gravel and using those drives. They simply failed to meet it. The problem is they are routinely acting outside of the stated operating hours. There's anecdotal evidence that we've presented, certainly by Mr. Brink and others in the materials we submitted, that anecdotally demonstrate that they arrive well before 8 in the morning and they're there well past 5 in the evening to do that. The other thing, I guess, more disturbing is the anecdotal stories you will see recounted in the materials we submitted, where they were openly mocking the residents next to them. And I think that shows an attitude, whether it was Mr. Etter, one of the Mr. Etters, or one of their, or more of their employees, mocking the good neighbors next to them shows a distinct disdain for being good neighbors. And I think it's important that the Board of Zoning Appeals understand that while Mr. Prine is going to represent them as the most upstanding citizens, and in fact, I respect Eric and his opinion, that doesn't mean that we can ignore their past behavior. And the best predictor of future behavior is past behavior. And I think it's important to know that. Moving more importantly, or more directly, to the criteria for the findings of fact, there's absolutely nothing to suggest that their continued compliance with these matters isn't going to be something subject to continued enforcement. They've agreed not to store any chemicals. Does that mean that a landscaping company is never going to have fertilizer? Does that mean that they're never going to have any kind of weed control product? Does that mean that they're never going to have any kind of nitrogen products on that premises whatsoever that aren't going to be loaded and offloaded to trucks, that aren't going to be spilled on the ground? And I think that the primary health concern is that the groundwater, the surface water travels from the east to the west across that property. Dr. Bob's property, if that pond overflows, flows across this property and everything ends up, as it flows across there, in the ponds that belong to Ashwood. Those ponds are what are utilized to irrigate the yards and the grass and the foliage and all of Ashwood. So even a gas spill, even a diesel fuel spill on the pavement is going to migrate either above or below ground into the Ashwood ponds, and you simply can't avoid that. And that certainly creates a health concern that was not addressed by staff, that was not addressed by Mr. Prine's presentation. I have Bruce Richardson here. Bruce is a realtor, a long realtor, and I asked his opinion briefly as a witness as to whether or not his professional opinion as to whether or not this commercial use is going to affect the property values of Ashwood. Bruce?
Thank you, Lee. Tom Brink is a neighbor directly to the west of this property. Tom is the one that has supplied the majority of the photos and the information that we've used. So the real estate values, Tom has noticed a tremendous impact on the equipment coming and going, and he's felt it in his home. So that'll directly impact the value of those homes that go next to this property, and that will then indirectly affect every home in Ashwood as it relates to the ability to sell these properties, looking out to all this equipment on the landscaping business. So every home in Ashwood will be indirectly affected, along with those that are directly next to the property.
Thank you, Bruce. I think that addressing the findings of fact that are required, it's interesting. The past use of this property is the only thing cited by the petitioners to suggest that this is a peculiar condition. Past use, and it must be noted here, that the Bennesses did not operate a plumbing business, and quite frankly, a relatively small plumbing business, since 2008. So well over a decade since there was any kind of real commercial activity there. And in fact, not to have 5 or 6 employees coming in and pulling heavy equipment in and out on a daily basis. There is absolutely nothing peculiar about this property that requires it to be given a use variance. It is a very peaceful, very pretty, very well maintained, serene, single family residence. It has the benefit of having some large outbuildings, a very, very desirable residence sold simply as a residence, because you have tractors you can store, you have a small workshop of your own, you have outbuildings, and in Greenwood, that is getting increasingly difficult to find residential property where you can have sizable outbuildings. So there is nothing, absolutely nothing peculiar about this property that requires that it be granted a use variance. In fact, its value to the neighborhood much greater. The other issue that was suggested is that it would create a hardship if this were not granted. There is no hardship if you are simply wrong about zoning and you don't check it out when you purchase it. It's not a hardship to the property. It may at this point be an inconvenience or somewhat of a hardship to the heirs who purchased it without doing their appropriate due diligence. But their lack of due diligence doesn't create a hardship on this property. So it completely fails to meet the criteria set forth by statute, except for number 5, which I think is not particularly relevant here. There is a health hazard. There is no particular condition that needs to be used. It will devalue the properties in the area, and the strict application of the R1 zoning in this does not create a hardship on the property unless you want to use it for commercial use. And you can't create a problem of your own request and then suggest that's a hardship if you don't get it. All right. The primary presentation done by the petitioner suggested that the reason this should be granted is because historically there has been some sort of operation on that property. That is not a reason to grant a use variance. We're talking about 3 to 5 to 6 employees that are going to be driving trucks in and out of there all day. They're going to be hauling heavy equipment out of that barn on a daily basis. That is much, much different than any commercial activity along there. Mr. Perkins, in fact, does that. But as you'll notice on the pictures that Mr. Prime provided, you don't see his large outbuilding from the street. You see a nice home. Not only that, but that's a private car storage workshop for him. He doesn't drive people in and out of there. That's vastly different than 5 to 6 employees driving their cars and or pickup trucks in there, using heavy trucks to haul heavy equipment out and in on a daily basis. That's a substantially more intense use. And quite frankly, I can't imagine that any residential neighborhood thinks that that kind of use is just going to be, oh, it'll be fine, just 5 to 8, because it's not 5 to 8. They get there before, they leave after. You have heavy equipment moving in and out of there on a daily basis. That area is a particularly serene area of Greenwood. You have these large lot houses to the north. You've got Ashwood that sets to the west, and up and down Demery Road is an extraordinarily nice area of Greenwood. Why in the world would anyone think that putting a commercial operation to haul heavy equipment in and out of there on a daily basis is doing anything but damaging and diminishing the quality of life for those residents? It just doesn't fit. And it doesn't need to be done. It's a use variance. That it is on the petitioner to convince you that all of those things are not true. And they simply have not done that. In fact, the evidence before you that we've submitted, the anecdotal evidence in spreadsheet form that Mr. Brink has submitted, the issues with regard to surface and groundwater drainage, none of those things were addressed either by the staff or by the petitioners. So we think they have failed on 4 of the 5 criteria that they need to establish. They simply haven't done it. They do not meet the requirements for a use variance, and we ask that this petition be denied. Thank you.
Thank you, Mr. Money. Anyone else to speak on the remonstrator behalf?
Yes, please.
Who is this?
Linda Abel.
Okay. Linda, we're going to have you get sworn in by our secretary.
Okay.
I swear under penalties for perjury, the testimony you're about to give is true to the best of your knowledge.
It is. I do.
And what is the address?
1545 Hazelwood Court East, Greenwood, 46143.
All right, Ms. Sable, we have
Mr.
7
Chairman?
minutes. We have
Mr.
7 minutes
Chairman?
left. Yes,
Yeah, that's what I was going to ask. How much time is left?
we have 7 minutes left, so I would
Okay,
try
I'll
not
be
to
quick.
repeat anything that's already been said.
I will be very quick. I will be very quick and to the point. Even if they keep to their original size commitment on opening, every business wants to continue to grow and cause more disruption in the future. Most landscaping businesses earn money in the winter through plowing. Is there any reason that they wouldn't do this? This would cause noise disruption all hours of the day and night. Once this is approved, what would stop them from doing snow plowing in the winter? A new business is unlikely to afford sufficient chemical spill insurance. Even though you say they won't do this, they have proved that they are unlikely to follow the rules. Ashwood is a unique community both in homes, landscape, and maintenance. We are the largest enclave of ash trees in Indiana. We water our lawns from our ponds. We own our streets, which means we plow, no hazardous salts. We maintain them. This does not cost Greenwood any money to maintain our roads and our grass, anything else. You don't do that. Personally, my husband and I have looked for 2 years prior to moving here. There is nothing like this in any of the adjoining states. This is a jewel in Greenwood's crown. Carmel doesn't have anything like this. Please don't approve this variance. Thank you.
Thank you, Ms. Sable. Anyone else? Okay, seeing none, Mr. Prime, we'll turn it back over to you. You have 5 minutes to respond.
Thank you. Well, I applaud Mr. Money. He did a nice job for his clients, but painting a dire picture of this situation without any specific evidence to support it is not really fair. Talking about heavy equipment coming in and out and in and out, that paints a picture in your mind. But the way this company operates, they leave in the morning, the trailer's gone with the mowing equipment on it, and they don't come back again until they're done in the evening after they've finished all of the services and the calls for that day. So it's not a constant in and out. The discussion about migration of oil spills and chemical spills, the Bennis's have all of the mentioned items on their property right now. They have fertilizer, they have weed killer, and they have for decades. We checked the IDEM database. There are 0 IDEM reports that have ever been made with regard to any issues on this property. And as Mr. Money pointed out, past performance is some indication of future compliance. And in this case, there is no history of any chemical spills or any issues, and we're not going to have chemicals on the property. So again, that's a red herring, and I think just designed to scare folks into thinking this is going to be some horrible operation when in fact it's going to be no different than what's been going on there before. And all of these folks that are remonstrating came to this situation, seeing the barns, knowing that this was there, knowing that Mr. Perkins operated across the street. This isn't anything new. We're not asking to come in and plunk down some heavily trafficked retail operation on top of a quiet residential area. This is somebody who's going to live in the property and use it for storage of his and the office for his business. And again, if it was something new, if this was something completely off the cuff and had never been done there before, I could see people being upset about it. In this instance, when they built their homes and they walked those lots, they could see these outbuildings sitting there. They could see this use there and the commercial use through 2018 with the signs. The plumbing company had 15 employees. It wasn't a small operation. So with all of that said, this is not something that's going to be injurious to the local property values or to anything else. And I believe we've complied with the statutory criteria. And as staff has indicated, we request that this variance be granted. Thank you.
Kenny, you're not on.
Oh, sorry, I got muted again. Mr. Money, you have 5 minutes for your final response as well.
Thank you very much. Contrary to Mr. Prine's representation, this is entirely new. This is entirely off the cuff. No one for the past decade has hauled heavy machinery in and out of that property every single day in the summer, and quite frankly, as Ms. Abel pointed out, likely in the winter also. That's an extremely different use than it's ever been put to, and certainly hasn't been put to since 2008 when the Venices last operated a plumbing company out of there. It's entirely new. To the extent we didn't, I want to make sure that we offer all of the exhibits that we tendered to the commission as evidence. And while I thought we had covered that base, I just want to make certainly sure that we didn't. One last item that I think needs to be understood. Enforcement of those restrictions could be an issue of daily problems. Just the anecdotal stories, and again, with Mr. Brink's spreadsheet and information placed in there, the fact that you have employees in and out of there before 8 o'clock and after 5 o'clock, who's going to enforce that? That's going to be either Greenwood Police or code enforcement. If they don't store all the machinery in the building, or if they buy more machinery than they can store, who's going to enforce that? Are the police going to be called there on a morning by morning basis when they show up before 8? Are the police going to be called when they have to show up after 5 o'clock every evening? You've got an extraordinarily difficult set of criteria. Who's going to get to inspect to make sure that there's no chemicals stored on the building? Who's going to do that on a regular basis to ensure that these run? It's nearly impossible to enforce all of those restrictions on a daily basis. And it is certainly nearly practically impossible to do it with Greenwood code enforcement or with the Greenwood police. Those are the options. The penalty for their violation is actually a criminal maintaining a common nuisance. So that's going to require a police report every time one of the neighbors sees a violation here. And I will tell you, I'm certain that they will. And now created an untenable situation where an employer feels handcuffed to operate because his employees can't be there before 8 or after 5 because it's a violation. They may or may not store chemicals there. There's all kinds of issues with regard to ensuring compliance. I think that's just a dead practical consideration that the Board of Zoning Appeals, the city, on behalf of the city of Greenwood, has to evaluate. Even if everything they was true, can we possibly enforce this, and what's going to be the process for doing that? Because the Ashwood homeowners would be entitled absolutely to do that. And I will tell you, we're creating a much larger problem with enforcement of these things because they are so finite and required and would need to be. I thank the Board of Zoning Appeals for their attention and all who are participating. Thank you.
Thank you. All right, with that, I'm going to close the public hearing and open up for questions from the board. I guess I will start. My first question is, we've heard a lot about heavy equipment and trailers and trucks, and I guess I'm trying to get a better understanding of exactly what this type of equipment is. If it's standard stand behind mowers, or is this excavators or bobcats, or what are we talking about here that is actually being stored and used? Mr. Prime, I don't know if you can answer that for us.
Sure. Hang on one second. I'm not going to make the mistake of trying to share the screen again, but I did have a slide in my PowerPoint that talked about exactly what equipment the Edders had. If you give me 1 second, it's downloading on my phone slowly.
Yep.
I'll pull it up and read that to you.
Okay.
There we go. All right. The equipment owned by Austin Edder he has 3 pickup trucks, one of which is his daily driver. He has 1 dump truck that is under the size permitted by Article 4, Section 30F of the Greenwood Code of Ordinances. He has an enclosed trailer, haul behind trailer that actually stores the mowers and weed eaters and other landscape equipment. He has one Bobcat and one Dingo. That's it. So the daily in and out is the trailer with the mowers in it, and occasionally the dump truck, depending on what they need to do out at the sites. But the main in and out is pickup trucks and the trailer with the mower board.
So I guess my next question then would be, Ed, perhaps you, as a resident without storage units, I'm allowed to have a lot of that equipment, right? So how do we define the business versus, if I have a trailer and a couple trucks and I have some mowing equipment as a resident, I should be allowed to take that in and out. So I'm trying to understand a little bit more of how we define and police this, for lack of a better term, as a business.
Okay.
Yeah, I mean,
the city code outside of the zoning ordinance allows any resident to have one vehicle that they drive to and from work, a commercial vehicle that's rated at 26,000 gross weight or more. Pickup trucks, regular sized vans, and automobiles are exempt from that. So any citizen in Greenwood could have a half a dozen to a dozen pickup trucks and cars and things with commercial signage or advertising their business and phone numbers, those type of things. That would be permitted with or without a variance, because it's permitted under the other parts of the municipal code. So it would just be that aspect of it would be available to Mr. Etter, whether a variance is approved or not, to drive those. At the present time, what I've seen there and what he's testified to his attorney, even the one dump truck he has is not large enough to be a violation of that particular municipal code. So those vehicles could come and go.
Pierre with Cripe
has joined the meeting.
I'm sorry, Ed, go ahead and finish that up. You got interrupted right at the end.
And like I say, as the enclosed trailer, when I think of large equipment, keep in mind here in our office, we deal with a lot of construction and development projects. We think of larger equipment, earth movers and backhoes and
right,
those type of things, and there won't be any of that there. The other aspect of this that I think both the board and interested parties need to realize, we permit, and this is common throughout Indiana, there are probably very few, if any, communities that don't allow this, but any land in Greenwood, regardless of the zoning category, if it's not developed, is permitted use as agricultural cropland. So again, without any variances or any other approvals, anyone who lived there or farmed that land, if they chose to, could have large equipment in the form of combines and corn pickers and that type of thing would be permitted and could be on that property without any variances or spatial approvals. So that's just another aspect of considering for the board.
Okay, and then I guess my next question
Hope
is,
I answered your question.
yeah, so the idea of plowing in the winter, which is one of the concerns I had too, but again, if I have a pickup truck, I'm assuming I'm allowed to have a plow on that pickup truck without any restrictions, correct?
Correct.
So forgive me for this, but I'm struggling now. What is specific that the Etters, what is it specifically that they need to conduct the business as they're doing it if everything they have fits within a legal residential use?
Well, they want to have an office in one of those buildings, accessory buildings, and they want to have outside employees coming and going. And those are things that would require use variance. That basically be the only difference between what they're allowed to do now and what it would be in the future if this was approved.
Gotcha. And that's what helps, I guess, keep that from happening where they have several vehicles and people coming and going, because that becomes where you have a number of employees and it does become more a business than a residential storage. Okay, that does help me. Thank you.
One other
Appreciate that.
comment for the record, there are no chemicals involved in this, and that was part of our discussion questions I asked early on. That's why chemicals were not addressed in the staff report.
Yep, understood. Okay, that is all I have. Mr. Smith, I'll start with you if you have additional questions.
Yeah, I've got quite a few here. So we talked about the equipment here, but along with that equipment, typically comes, oil, antifreeze, gasoline, or any of how are these going to be stored by the petitioner? Are there above ground storage tanks? How are they planning on accommodating this?
Mr. Prime, I don't know if you know the answer to that. I guess my assumption is, and it's a good question, Mr. Smith, is that it would be standard consumer grade gas cans, gas tanks, oil cans, that kind of thing. But is there something?
Correct. No, there won't be anything greater than that. They're not going to have huge storage tanks or anything like that. It'll be the standard things that you and I would have in our garage.
Okay. Okay. That's great. On this, for their generator status, and this is again maybe something that you don't know the answer to, Mr. Prime. Typically, under the Resource Conservation Recovery Act, there's some statuses that you have as a business. If we were to approve it today, could they, as one of the conditions, say that they would be beholden to staying in a conditionally exempt small quantity generator status, which means that they can't produce more than 220 pounds of hazardous waste per month from their business? Would that be something they'd be amenable to?
I can't imagine why they would have a problem with that. I don't think they're intending to produce any hazardous waste. So, yeah.
Okay. Yeah. Question for Mr. Money here. You mentioned something about antagonizing the neighbors. What can you elaborate on that? What did you mean by they said they antagonized some neighbors?
I can. There's anecdotal stories, and I think if you read through the exhibits that we submitted, and there were some additional letters that were submitted directly from individual residents to the Board of Zoning Appeals on their own. It didn't come through my office. Employees waving at them, employees, and I don't want to suggest that was necessarily in a friendly manner, as I understand the anecdotal stories, that they were essentially mocking the neighbors that were there. I didn't witness it personally. I'd be happy to, if any of if Tom Brink is still on and Tom Brink would like to address that, because he's the one that saw it and he's the one that noted it, I'd be happy for Tom Brink to relate to what he saw and heard.
Am I live? Can you hear me?
Yeah, is that Mr. Brink?
Yes, it is.
Yeah, Lori, I think we're going to have to swear Mr. Brink in, and he did not speak during the public hearing, but I'll make an exception just in order to answer the board member's question here.
Okay, thank you. Tom Brink, raise your right hand, please.
Okay.
You swear under penalties for perjury the testimony you're about to give is true to the best of your knowledge?
Yes, I am.
Thank you.
Okay, go ahead, Mr. Brink, and answer the question.
Probably the most specific thing, the workers would gather fences between the two buildings. I'm hearing a lot of feedback. Can you hear me?
There is a slight echo, Mr. Brink.
Okay, the workers would, almost every window in our unit, our house faces this location. We would be inside eating a meal at our kitchen table, and they'd stand over there and would just wave to us. So we would be outside in our yard. They were peering through our windows. If we were outside in the yard, for example, we would take a picture of all the equipment. In fact, there's a lot of equipment not mentioned by Mr. Prime in this description, but we were taking a picture. They would then start waving at us. They'd drive around in a truck. In fact, I think maybe it was a photograph submitted of and waving.
Okay.
Right.
Thank you, Mr. Brink.
And they weren't friendly waves.
Yeah, I understood.
Just one last thing for me on this one. Mr. Prime, you didn't really address Mr. Money's contention that that the petitioner had gone forward with several things outside of the code of Greenwood, even though they'd been served with cease and desist orders. Can you address that, please, Mr. Prime? Oh, you're muted, Mr. Prime.
There we go. I don't know all of the history prior to my clients engaging me to assist them with this variance petition, but I think it stems from the fact that most lay people don't know all the rules and the zoning ordinances. And because this area was used as a commercial use prior, they thought they were okay. Now, once that first letter came out, you might say, what happened? I believe they didn't get that first letter, that it was sent or left at the address now, and the editors weren't there then, and it didn't get to them. They had a personal phone call after that from Ed Ferguson with the city, and at that point they all got on the same page and stopped the activity. And I think, just back to Mr. Brink's position, if that's mocking people, waving at you while you're videoing them, I guess, we've all seen a lot worse than that lately, but yeah, so be it.
Okay, thanks, Mr. Prime. All right, Mr. Smith, any others?
No, thank you.
All right, Mr. Polar? Anything additional?
No questions.
Okay, Mr. Foster?
I have no questions.
And then Mrs. Peters?
I just have a couple of comments the way I'm reading all of this. So if we don't approve the variance, the folks there don't have to change the driveway. They can continue with their gravel driveway and add more gravel if they want. They don't have to put any buffering between the housing addition and their property. And the outbuildings are still going to stay if they want to keep them. Is that correct?
That's partially correct. They still have to either remove the gravel that was installed or pave it to comply with that aspect of the city ordinances.
But it's if they're not getting approved for a variance, that's just a normal way that it was before, and they're grandfathered in.
No, some of the stone area farther south, it's actually in front of the accessory buildings, is grandfathered in. All of the new stone that was added this spring is not grandfathered and would have to comply with the parking and paving ordinances of the city.
Okay, so any new drives
Aware
they
of
put
that.
in.
We've discussed that. He's indicated to me they intend to pave it, but they were waiting to see the results of this hearing.
So they could essentially have pavement over the new part that they expanded their driveway for, and everything else would be gravel.
Yes. But now the main driveway from the Demery Road back to the house and behind the house is paved.
It's already paved.
The only grandfathered part is the stone area that's along the east side of the garage and barn.
Okay, but the outbuildings, they can keep the outbuildings. They don't have to put up any trees or anything, and everything stay as is. Okay, all right. I just want to make sure I understood it correctly.
Okay. No further questions from the board? All right. I will, I guess, wrap this up then with just a couple comments. I think we've heard a lot here tonight. There's a lot to consider. At the end of the day, again, our role is to determine if we believe the petitioner or the remonstrators when it comes to the approvals, the statement of reasons for the variance, right? So whether or not it is or is not injurious to public health, safety, morals, whether it is going to lower the use and value of the area adjacent to the property, and again, the condition peculiar to the property. So ask everyone to keep that in mind as they think about taking decision here. So With that, we will close. I will take are all the notices and receipts in order?
Yes.
Okay. I'll take a motion to accept. Oh, sorry, go ahead, Sergey.
Ms. Kennard, sir, I also like to notify the board that I submitted certified copies of comprehensive plan and zoning ordinance into record.
Yes. I'll take a motion to put all that into record.
So moved.
I'm going to read from the,
Yes. Yeah, we need to read that in. If anyone has it.
Got
Mr.
it
Chairman,
here. Okay, Chairman. I move that we admit all the evidence presented in regard to this matter, including the notices, receipts, maps, photographs, written documents, petitioner's application and attachments, petitioner's detailed statement of reasons, the staff report prepared by the planning department, certified copies of the zoning ordinance and comprehensive plan, testimony of the petitioner, city planning staff, and any remonstrators, and all other exhibits presented, be they oral or written, for consideration by this board in regard to this petition, and to include the testimony of those present this evening.
second.
Motion by Mr. Peters, second by Mr. Polar. Mr. Polar, yes, yay or nay?
Yay.
Yeah, Mr. Smith,
Yay.
Mrs. Peters,
Yay.
and Mr. Foster.
yay.
And I'm a yay. Motion carries 5-0. I will take a motion on the docket itself.
Just for the findings of fact.
No, this is an actual to approve or deny the docket. I need a motion one way or the other.
Mr. President, I motion that we deny docket V 2020-10 dimensional variance for lot B, section 4, block B, lot 1, Emerson and Maine.
No, this is
1444 Demery Road.
Oh, excuse me. This is, excuse me. I motion that we deny docket V 2020-011 for the property located at 1444 West Demery Road.
Do I have a second? Is that Mr. Foster?
Yes.
Yep. Motion by Mr. Smith, second by Mr. Foster to deny the ballot. So keep in mind when I ask for your vote, a yay is that you deny and a nay is that you don't agree with the denial. So Mr. Foster?
Kenny,
Yes.
Kenny, we
Correct.
need to correct the docket number. He quoted V 2020-01. This is V 2020-11.
He said 011, but it is docket 11 for
Yes.
V 2020 docket 11. Yes, that is correct. Okay, so again, if you agree with the denial motion, then it is a yay. If you do not, it is a nay. So, Mr. Polar,
nay.
Mr. Smith,
Yay.
Mrs. Peters,
Nay.
Mr. Foster,
Yay.
and I am a yay. So the motion will be denied 3-2. Then I will need a motion to take final action at our next meeting.
As a
Mr. Chairman?
reminder, make sure to complete your ballots and send them back in to us.
Yep.
Mr. Chairman, having considered the statutory criteria, I move we direct the Corporation Counsel's Office to draft written findings of fact regarding our decision on the variance request presented in variance petition number V 2020-11. Said findings to specifically incorporate the staff report and the evidence submitted into the record for consideration and adoption by the Board of Zoning Appeals as our final decision and final action regarding the petition at our next meeting.
Second.
Second.
Motion and a second. Mr. Polar,
has joined the
Yay.
meeting.
Mr. Smith,
Yay.
Mr. Peters,
Yay.
Mr. Foster,
Yay.
and I'm a yay. Motion carries 5-0. Thank you all. For those that were here for just this docket, you're welcome to drop. I know we have the Planning Commission coming on board. We still have a couple things on the agenda, which I will address here shortly, but I want to give everyone an opportunity to disconnect first.
Hi, Mary Lou Meyer. Has left the meeting. Sally and Jean Perkins.
Has left the meeting. A participant has left the meeting.
Okay. So we're obviously running very long here. We had some technical difficulties. We have a planning commission coming up after this. We still have docket 2020-12 and 2020-13, which are for the same community. And I believe Mr.
Nora
Prime,
Keston has left the meeting.
they're identical requests, correct? For two
Initially,
different-
but I think the petitioner wants to propose an amendment to the second one, but we'll have to let
Okay.
Mr. Prime discuss that.
So I have two questions here, I guess, with that. One, from a process standpoint, well, I guess if they aren't completely identical, I was going to ask if they're completely identical, if we can hear evidence for both of them at the same time and then vote on them separately, as opposed to repeating all the evidence. So that would be my question to Sergey.
So you can do that as long as, from what I can say, is just two different lots. If the presentation is identical, they can be incorporated into one, and then you can vote on each docket separately, or rather, you'll be required to do it separately.
Okay. And then Mr. Prime, I'll come back to you on that. If you want to do that, we are more than willing to keep going here tonight. I guess my other question would be, I don't know the time sensitivity of this, if this would be, if we have an opening in 2 weeks, if you would be okay with a request to continue these two. And Ed, I guess before he answers that, what is our schedule look like for the next meeting?
Broke on me.
We have no other petitions filed as of this time, so there'll be no new business.
Okay, so Mr. Prime, with that, I'll let you decide. We're willing to continue, but in the essence of the planning commission and everybody's time, I just wanted to throw that out there.
Yeah, and I'm sorry, Mr. Chairman, I didn't hear almost anything that you said.
Oh, sorry.
It froze on my end, maybe.
The question was, one, with the time and the delays we've had, I don't know the time sensitivity of these two dockets. Could we request a continuance for our next meeting in 2 weeks, which has no other things on the agenda currently? Or if we can't do that, then could we take evidence for both petitions at the same time, since they are identical in nature?
Yeah, absolutely. We could do both at the same time. And this is a pretty minor thing. So I think we can, if everyone will bear with me for a second here, we'll try to squeeze this in real quick, if that's all right.
Yep, absolutely. We're here, so
right.
I am.
No, go ahead.
Okay, so we're going to, well, I guess the next question, Mr. Prime, then is, Ed thought there might be an adjustment to one of these. Is that correct, or are they?
The adjustment was that on lot 61, they found a 1 foot plat amendment, plat correction that had been done, which assists to some extent on that one, but it doesn't completely cure the issue. So we left it on the docket.
Okay, so they are still identical, going from 8 feet to 7 feet.
Correct.
Okay, so from a board perspective, both of these petitions are going to have the same testimony. They're both being read for the same request, which is to reduce the side yard setback from 8 feet to 7 feet in an R2B zone. We're talking lot number 61 in Heritage Trace, section 1, which is docket V 2020-013. And then docket V 2020-012 is for lot number 1 in Heritage Trace. Okay. With that, Eric, why don't you quickly tell us what you're asking for and go through the criteria, and then we'll ask questions. So I guess before we do that, I'm sorry, Lori, do we need to swear him in again since these are new?
I don't believe so. Do we sort of do a double swear?
The petitioner is different in this docket. Mr. Prime is just an attorney for petitioner.
Okay.
Yeah, so let's swear him in again. And before we do that, Lori, let me ask, is there anyone else going to speak to this or against this? Okay, in that case, go ahead, Lori.
Okay, please raise your right hand. Do you swear under penalties for perjury the testimony you're about to give is true to the best of your knowledge?
I do.
Thank you.
All right, go ahead, Mr. Prime.
Thank you. Eric Prime on behalf of the petitioner, Beezer Homes of Indiana LLP. We are talking about the Heritage Trace subdivision, and there are two lots that are lots that require under the city's architectural standards brick wrap. In these two instances out of this whole subdivision, where these lots sit, and because of the brick wrap requirement, we are requesting a 1 foot on each side yard setback variance. So instead of 8 feet on each side, we're requesting that we go to 7 feet on each side. And that's simply to allow for, that's the amount, we're that tight on a 40-foot wide home going on these lots, and adding the brick is that foot. So if we can get a 1 foot relief on just these two lots, then they can be buildable. If we can't get that relief, we can't comply with the city's zoning ordinance. So either we need to come back and ask for a variance for no brick, which is a non-starter, or we can get a 1 foot variance on each of these lots to allow for the brick wrap. And that's really in a nutshell what we're here about today. And so the statutory criteria, which would be the same for both, are as follows. One, the approval will not be injurious to public health, safety, morals, or general welfare of the community. I can't imagine in any way, shape, or form that a 1 foot difference in a side yard setback is going to be injurious to anybody's health, safety, or welfare. There's still plenty of room to get fire equipment, fire personnel through there. In fact, each of these lots abuts a common area on one side and a house on the other, but the common area side will be wide open to come through. We just can't go into the common area with the build. It's off the lot. So I don't think there's any public safety issues here at all. Two, that the use and value of the area adjacent to the property included in the variance will not be affected in a substantially adverse manner. These are all single family homes. It will be such a de minimis difference viewing from the street that the naked eye won't be able to tell that there's a 7 yard side yard setback or 7 foot side yard setback instead of an 8 foot side yard setback. So they'll still be single family homes. They'll still be harmonious with the rest of the subdivision. Three, the strict application of the terms of the zoning ordinance will result in practical difficulties in the use of the property. As I've stated, because of the zoning ordinance, because of where these properties sit, they are required to have full brick wrap on the first floor. And we can't do that on just these two lots. These two lots in particular are too thin to permit that. The one lot, 61, we might make it by like an inch, but we'd hate to have a situation where we're out of compliance with the ordinance because we were that close. So a foot on each side gives us enough clearance to be sure that we're going to comply with the side yard setback requirement, but also allow for the full brick wrap. And then the final one is that the structure is not regulated under in the Hazard Air Navigation Act, Indiana Code 821-10-3. This is not within the airport zone, so is not applicable. Staff had no objections to any of our statement of reasons and requested no conditions and recommended approval for each of these petitions. And I would reiterate for the record that the statutory criteria are exactly the same on petition V 2020-12 and V 2020-13.
Okay, thank you. Anything else to add before I close the public hearing? Okay, public hearing is closed. Open it up to the board members. Mr. Poehler. Trent, do you have, Mr. Poehler, do you have anything questions or comments? You might be on mute. Mr. Smith?
I do not.
No question, sorry.
Okay. All right. Mr. Peters, or Mrs. Peters, rather, sorry.
No questions.
And Mr. Foster?
No question.
I have none either. I will, are the receipts and notices and everything in order?
Yes, I submitted.
Yes, they are. They're in the file.
Sorry.
Go ahead, Sergey.
Submitted copies for comprehensive plan and zoning ordinance into record. I just want to make sure as well, are there any remonstrators against those petitions present?
Oh, thank you. I thought I had asked that earlier, but
It's not.
I appreciate it. All right, I'll take a request to accept all that into the record.
I move that we admit all the evidence presented in regard to this matter, including the notices, receipts, maps, photographs, written documents, petitioner's application and attachments, petitioner's detailed statement of reasons, the staff report prepared by the planning department, certified copies of the zoning ordinance and comprehensive plan, testimony of the petitioner, city planning staff and and any remonstrators, and all other exhibits presented, be they oral or written, for consideration by this board in regard to this petition, and to include the testimony to those present this evening.
Motion by Mr. Polar. Do I have a second?
Second.
Terry Kendall.
Has joined the meeting.
A motion and a second. Mr. Polar,
Yay.
Mr. Smith,
Yay.
Mrs. Peters,
Yay.
Mr. Foster.
Yay.
I'm a yay. That's motion carries 5-0. I'll take a motion to either approve or deny, starting with V 2020-12, lot number 1.
Motion to approve.
Mr. Chairman, I would move to approve V 2020-12.
Second.
Have a motion by Mr. Foster, second by Mr. Polar. Mr. Polar, your vote?
Yay.
Mr. Smith?
Yay.
Mrs. Peters?
Yay.
And Mr. Foster?
Yay.
And I am a yay. Motion carries 5-0 without any conditions. I'll take the motion on V 2020-13, which is lot number 61.
Mr. Chairman, I would move to approve V 2020-13. Wait, I'm sorry, you wanted the different motion?
No, that's exactly right.
Oh,
Yep.
Second.
Okay, a motion and a second to approve without any conditions. Mr. Polar?
Yay.
Mr. Smith?
Yay.
Mr. Smith, I didn't catch you. I'm sorry.
Yay.
Okay, Mrs. Peters?
Yay.
Mr. Foster?
yay.
And I'm a yay. Motion carries 5-0. I now need a motion to take our final action on both of these ballots at our next meeting.
Mr. Chairman, I haven't considered statutory criteria. I move that we direct the Corporation Counsel's Office draft written findings of fact regarding our decision. The variance request presented in various petitions V 2020-12 and V 2020-13. Said findings specifically to incorporate the staff report, the evidence submitted into the record for consideration and adoption by the Board of Zoning Appeals and our final decision, final action regarding the petition at our next meeting.
Second.
Motion and a second. Mr. Polar?
Yeah. Yay.
Mr. Smith?
Yay.
Mrs. Peters?
Yay.
Mr. Foster?
Yay.
I'm a yay. Motion carries 5-0. Thank you. And Mr. Prime, we will finalize that at the August, what did that be, the August 10th meeting.
All right, thank you very much. Thanks for indulging me. And I know it was a late meeting, but I promise you, as I said, that one was not going to be too bad.
No, we're happy to do it. Thank you for your time tonight.
Yep.
Okay, any new business from the floor? Seeing none. Any announcements, Ed?
I have none.
Has left the meeting.
Okay, Sergey?
None.
I'll take a motion to adjourn.
So
I would move to adjourn.
So the board, this adjourns the Board of Zoning Appeals. I don't know if you need to stop the recording. I think you're going to keep the recording going, so we will turn it over to the Planning Commission. Thanks, everybody.
Kenny,
Yes.
if we have no new business next time, are we still going to meet for the findings of fact?
That's a great question, Ed. Do we need to do that, or are we going to wait for the following?
That's your call. If you want.
We have 3 findings, so we may want to do that.
We should probably do that. We can get on at 6 o'clock real quickly and do that. That way they don't have to wait another 2 weeks.
Yeah, and if I don't know what the Plan Commission agenda is for that night, but if they meet, sometimes we might push this meeting back.
Yeah, I don't know if we necessarily need to do that with it being remote, though, do we?
Well, that's true.
It might actually give a little bit of a break for time for people to drop and join too. So either way, just let us know which one you want to handle.
Will do.
Okay. Thank you. And that definitely concludes the board of zoning. So thank you.
Thank you.
Thank you, everybody.
I'll take it from here. Do we want to have a couple minutes for everybody to get organized?
If we can have just 30 seconds.
That's
Because
fine.
I'll be representing Plan Commission tonight because Sean is
Yes.
out for personal
Ed
matter.
Ferguson.
Yeah.
Has left the meeting.
Just let us know when you're ready, Sergey.
Thank you very much. I appreciate that.
Died is Bruce's former brother-in-law. Married his tough. I never heard of Sergey Kuchek.
All right, all ready to go. I apologize for that.
I believe looks like we have everybody in order. I'll go ahead and I'll take roll. Mr. Walker?
I'm here.
Mr. Johnston?
Here.
Mr. Shell? Mr. Shell?
Present.
Mr. Smith?
Here.
Monica?
Here.
Ms. Gardner?
Here.
Mr. Schrader?
Here.
Mr. Dine?
Here.
And obviously I'm here. Okay, so our first, first of all, let me call to order the Advisory Plan Commission for Monday, July 27th, 2020. First order of business is the approval of the minutes from June 22nd.
Motion to approve, Mr. President.
And who was that?
John Kell.
Okay.
Second by Brian Walker.
All right, motion by Mr. Shell and second by Mr. Walker. Mr. Walker, yay?
Yes.
Aye.
Mr. Johnston?
Aye.
Mr. Powell?
Yes.
Mr. Smith?
Yes.
Monica?
Yes.
Ms. Gardner?
Yes.
Mr. Schrader?
Yes.
Mr. Dine?
Yes.
And I'm a yes as well. Okay, any special requests or continuances? Seeing none, any business from the floor? Seeing none, under new business. PC 2020-024, South Tech Building number 5. Who is the petitioner for this, please? Do we have the presenter?
Is anyone from Becknell or Structure Point on the line?
Hi, this is Steph here with Cripe. I can do South Tech number 5. Hello, can everybody hear me?
I believe so, yes.
Okay. Well, this is a request for a variance on the west side of the site because we had to move the building from the property on the east side because it's residential. We had to have a setback about 100 feet, which reduced the side setback we'd have on the west side, which is near a pond. So we're requesting the waiver for the landscape there because we won't have enough room to put landscape between the pond, the property line, and the back of the curb. The reduction for that, I think we have about 0.6 feet from the back of the curb to the property line, so we won't be able to meet the 10-feet setback required for that area.
I think we were old business because it got continued in July, or June to July. And they're in new business now.
Okay. Is there, Sergey, let me double check with you. This was not supposed to be a public hearing. Is that correct?
That's correct.
Okay.
That is correct, yes.
Okay. So is there any questions from the commission?
I have none.
We're just gonna turn it down.
There's been I believe there's been a motion prepared. See if I can find those. Hold on just a second. Bear with me here.
You need a number for him?
Okay, there has been a motion prepared. Does anybody have that?
President, this is Daniel. I've got it.
Okay.
I move that the request of Becknell Industries in the matter of South Tech Lot 5, Building 5, Commercial Site Development Plan for a waiver of the requirements of the I-65 Corridor Overlay Zone District Ordinance, Greenwood Municipal Code, Chapter 10, Article 6, Section 10-101, 6.17.23 areas to be landscaped, a minimum landscaped areas, 3 peripheral planting that specifies there shall be a 4-foot wide peripheral landscaping strip along the side of any private parking area that abuts to permit no peripheral landscaping along the side of South Tech Lot 5's parking area abutting the west property line be approved, and that the Plan Commission find that Becknell Industrial has met the criteria set forth by Greenwood Municipal Code Section 10-472, 18-11A for the waiver for the reasons set forth in its request for waiver and as presented.
Second.
Is that Mr. Smith?
It is.
Okay. I would remind anybody that's not speaking to mute yourself so to avoid any background noise. All right, there's been a motion by Mr. Johnston and a second by Mr. Smith. I'll go through and take the vote. Mr. Walker? Mr. Walker? Are you on mute?
Kyle.
Mm-hmm.
Mr. My phone is not dead. I'm working on a solution. We'll probably limit email communication.
Any of those speaking, could you mute yourselves, please? All right, try again. Mr. Walker? Are you on mute, Mr. Walker? Mr. Johnson?
Aye.
Mr. Shell?
Aye.
So when they
Mr.
do
Smith?
business, you
Aye.
do
Monica?
new business and then they do old business, or do they old business
Old
and
business and
new?
new business. I think we were old business because we were continued.
Monica?
Aye.
Mrs. Gardner?
Aye.
Mr. Schrader?
Aye.
Mr. Dine?
See what happens after this one.
Mr. Dine? And I'm an aye. Motion carries. Okay. Second order of business under new business would be PC 2020-043 e-commerce easement vacation. Request the vacation of a drainage and utility easement at 2441 East Main Street. And who might be the petitioner on this?
You have Justin Olashik from American Structure Point.
Justin Olashik. Okay. State your address for the record, please.
The work address is 9025 River Road, Indianapolis, Indiana.
A participant has joined the meeting.
Present your petition, please.
So we are hoping to vacate an existing drainage and utility easement. This property is located at the intersection of Main Street and East Commerce Drive, Commerce Parkway East Drive, within the Precedent South Business Center. And the property that we are looking to develop is Block 8 in the platted Precedent South Business Center. Currently on site, there is a small detention basin which handles stormwater runoff from this property, as well as a portion of Commerce Parkway and the adjacent property to the west. What we are proposing in order to make this site a more developable site is we are hoping to vacate this existing drainage and utility easement in order to develop this site. And then we will be relocating the existing wet detention basin to the southeast corner of this property, and providing a new drainage and utility easement to handle all the aforementioned drainage for the current parcel, as well as any offsite that currently gets to that detention basin. So essentially, we're picking up and moving the easement to the southeast corner of this site to aid in our development.
Okay.
He sent you the same email. Okay, thank you.
Is there any questions from the petitioner or from the commission?
This is Brian Walker. Sorry about it. I got bumped off a minute ago. I wanted to mention that on the last item, my vote was yes, but I do have a question on this one. If we're vacating the easement, you mentioned that you were redirecting the water another way. Is that what you said?
Yes. So essentially, we'll be relocating the existing wet detention pond. It'll still be located on this block. It'll just be shifted to the southeast corner. So this existing property is kind of in an L-shaped configuration. So we'll be shifting the detention into the less developable corner of this site. We will be collecting all the right-of-way drainage and providing a new drainage and utility easement around that pond, as well as any of the infrastructure that has to be reconstructed with our development.
Okay, that wouldn't impact any adjoining properties at all, as far as we know?
It would not. We are currently under commercial site plan review through the city of Greenwood, so we are in the outside review process. But essentially, any of the offsite water that's getting there in the existing condition, we will be detaining in our new detention basin, so there'd be no adverse impacts to any of the adjacent properties.
Mr. Walker, this is Dale Davis. The site plan that they've presented is fairly consistent with the site plan that was presented when this was filed under a different project name, and it had to be rezoned. So they are fairly consistent with what we've seen before.
Okay, I just wanted to ask, you know, sometimes when those ditches, those drainage ditches get vacated, it turns into a problem, you know.
Terry Kendall has left the meeting.
So I just wanted to make sure that something was maintained for stormwater runoff and drainage. Thank you.
Okay. Any other questions from the commission? Seeing none, there's been a motion prepared.
I'll take that motion to, this is Brian Walker, make a motion to recommend to the Common Council the vacation of the variable drainage and utility easement and common area within Block 8, President South Business Center, Section 5, to move to find that the vacation of the platted variable drainage and utility easement and common area within Block 8, President South Business Center, Section 5 in the city of Greenwood, as proposed, would not, number one, hinder the growth or orderly development of the city of Greenwood or of the neighborhood in which they are located or to which they are contiguous. Number two, make access to the property by means of public way difficult or inconvenient. Number three, hinder the public access to the church, school, or other public building or place. Number four, hinder the use of a public way by the neighborhood in which they were located or which they are contiguous nor. And number five, adversely affect the health, safety, or welfare of the general public or delivery of services to the public. That the Planning Commission recommend that the platted variable drainage and utility easement and vacated as proposed, and to authorize the Planning Commission President to execute and deliver a memorandum regarding these findings and this recommendation to the Common Council in the Planning Commission's behalf.
Second.
Second by
Mr. Smith.
Okay. All right, motion by Mr. Walker and second by Mr. Smith. All those in favor, take a roll. Mr. Walker?
Yes.
Mr. Johnston?
Aye.
Mr. Shell?
Aye.
Mr. Smith?
Aye.
Magna?
Aye.
Ms. Gardner?
Aye.
Mr. Schrader?
Aye.
Mr. Dine? Mr. Dine? And myself is aye. Motion carries. All right, good luck. Thank you.
Thank you.
Next order of business is amendment to the Plan Commission's Rules of Procedures. Mr. Davis, I assume you're...
Yeah, with Cripe.
Has left the meeting.
Yes, so we were going through our rules of procedure and we realized that the way
Justin
interested
American Structure Point.
Has left the meeting.
So we realize that the way our interested parties are shown in our rules of procedure, the way they're defined, is not necessarily aligned with the notice requirements of state code. The way state code would require noticing of a new ordinance or something that would cover the entirety of the city as a newspaper publication, publishing on the website, everything we'd normally intend to do. But the way our rules are written, it would require certified mailed notice for the entirety of the city. So we wanted to amend the rules such that now we're aligned with state code. So the rules that have been prepared and presented for you redefine how the interested parties reads.
If I may add too, it is redefined in a specific instance where a petition proposes to repeal and replace the zoning ordinance or repeal and replace the zoning map. And that's what Mr. Davis is referring to. In those particular instances, we would have to give notice to the entirety of a city via mail, and this is what we're trying to avoid here. And we will be specifying it that notice shall be given by publication only.
So how is the public notified then? I may have missed something there, I apologize, but how is if we're not sending letters to, as I understand it, you're stating that it takes away letters being sent to all residences?
Right, so it's in this specific instances there where we're repealing and replacing the entire zoning ordinance, or repealing and replacing the zoning map, the interested parties would be would basically cover the entire city. So we're specifying that in these instances, the notice will be given by publication according to Indiana Code 5-3-1. So it's it's making sure that all the interested parties are notified properly in this specific instance of repeal and replace of zoning ordinance or repeal or replace zoning map.
Okay. Okay. Any questions or comments from the commission?
Hey, it's Monica. So what would those specific areas be? What if people don't get the paper, or are they going to post it at the city building, or how are we going to get it out to the public if it's not by mail?
I cannot the notice by publication means publication in the circulated newspaper. It's usually done by we use Daily Journal a lot, but it can also be done in other newspapers of general circulation. We also always do it on our website as well as a backup, and it of course will be available in the city center offices as well.
Okay.
And just to give you an example, and I think Dale can give you a little bit more information about that. In that specific instance, as you know, we are amending our entire zoning code. And in this specific instance, we had multiple workshops and presentations with the public in addition to the requirements by the state code, as well as a creation of a workshop, which Dale curated as well. So in those instances where the amendment is substantial, we go far beyond that the statute requires to notify the public properly and receive proper public comment as well.
And that's exactly correct. We have held a public open house. We've had a steering committee involved this whole time. We've really put the word out there a lot, and the whole message throughout that was that this will be going to Planning Commission, this will be going to council. There are hearings, there is input to be had. So everyone that's been involved along the way knows that these steps are coming up, and there's honestly been more opportunity to spread the word about this ordinance than there would have been just through normal means of mailings or something like that. We've been doing outreach for months, and we will continue to until it actually hits you guys's docket.
Are you using any type of social media?
Yes, the open house was published on all of our social media channels. We did a sort of a webinar where I recorded a video to introduce our ordinance and invite people to provide feedback through our Citizen Connect portal on the website. I've also taken phone calls and just direct emails, just compiling all of that feedback so we can revise the ordinance. We've also reached out significantly to our developers, both commercial and residential. We've had a lot of good feedback from those groups. So we've reached out as much as we can on this effort.
Great.
Okay, good deal. Now, I don't believe there's been a motion prepared, so I'll entertain a motion to approve new rules. Anyone?
Mr. President, I do not have a copy of the prepared motion.
There is not one, John.
It was not prepared. I